I'm Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the administration of justice in Madras 1639 to 1726. My dear viewers, the objectives of the present module are introduction, first stage from 1639 to 1665, second stage from 1665 to 1686, third stage from 1686 to 1726, and lastly the conclusion. Let's begin with a brief overview of the topic. The early centers of British power in India were the three presidency towns of Madras, Bombay and Calcutta, which were founded by the British. The East India Company had a factory at Masulipatam, which was merely an agency working under the chief factory of Surat. In 1639, one of the members of Masulipatam factory, Francis Day, secured permission from the local Hindu chief to construct a fortified English factory on strip land. This fort was named as Fort St. George, and the Englishmen and Europeans lived inside it. The company in this fortified settlement was empowered to mint money and govern Madras Pattinam, which was a small village near company's fort. This fortified settlement came to be known as the White Town because of its all white residents. A village inhabited by the local natives grew up adjacent to this English settlement and came to be known as the Black Town. In course of time, the entire territory comprising White Town and Black Town developed into the city of Madras. It was only in 1665 that the Madras factory, which was subordinate to Surat, was raised to the status of presidency. The judicial system in both these towns was distinctly separate from each other. Dear learners, let us discuss administration of justice in Madras in detail. The administration of justice in Madras presidency can be discussed under three stages, that are: first stage from 1639 to 1665, second stage from 1665 to 1686, and third stage from 1686 to 1726. Now, let us begin with first stage from 1639 to 1665. In the first phase of judicial administration in Madras, justice was at its rudimentary stage. As discussed earlier, the judicial system was designed primarily to administer justice to the Englishmen in all the three presidencies in India. Later on, many Indians were attracted to this place due to trade and lived outside the factory. The small village came to be known as Black Town. The whole area of White and Black Town came to be known as Madras. With the passage of time, the Indian population of these settlements increased, and therefore, there was a necessity to change the judicial system. King Chandragiri also gave the company full power and rights over the land. The East India Company had to change the administrative process, especially in judiciary, to satisfy the people of Madras Pattinam. Here, it is important to elaborate the administration by agent and his council. In the White Town, agent and his council decided both civil and criminal cases. When Madras was given the status of an agency, its administrative head was called the agent. He was assisted by a council. The agent and council were subordinate to Surat, which was the only presidency in India at the time. The scope of their judicial power was very vague and indefinite, and therefore, they hesitated in handling serious criminal cases and very often referred such cases to the company's authorities in England for advice. As communication between India and England in those days took a long time, administration of justice became very dilatory and unsatisfactory. The only available account of a case disposed of during this period is that of two Englishmen who were found guilty of sedition and were punished with the lash. In the beginning, affairs of the settlement were mostly commercial in nature and did not raise any complicated administrative problems. With the passage of time, these functions grew and became diversified. These two main agencies, that is, the agent and council, were authorized as ultimate authorities to decide disputes, issues and matters of both the civil and criminal cases in respect of the people in White Town. These two systems were headed only by merchants for the purpose of administration of justice. Being merchants, the delivery of justice was cumbersome for them, as they did not have any knowledge of law, of both civil and criminal. So, they disposed most of the cases only with their limited conscience, knowledge and common sense. Next was Choltry Court. In the Black Town, prior to British settlement, Choltry courts were functioning for administering justice to the natives residing in Madras Pattinam. Each Choltry court was headed by a native village headman who was known as Adhigar or Adhikari. Adhikaris dealt with only cases of small causes, but were not entitled to deal with complicated civil matters or serious offences like murder. So, the consequential appeal arising out of such simple matters were taken before the appellate forum, viz. Agent and council, who were vested with powers of appellate jurisdiction. There were instances of removal of service of such adhikaris when they misused their power for personal gain. The legal history of Madras Pattinam reveals that Adhigar Kannappa, who inherited the office from his father, was dismissed by agent and his council on charges of corruption and misuse of power, and two English servants of the East India Company, Captain Maston and John Light, were appointed in his place at the Choltry Court. Thus, it is evident that in the initial stage there was no established procedure for trial of the cases, and the native judges were laymen deciding cases according to their own notions of justice. Dear learners, now I will throw light upon the changes introduced by the Charter of 1661. The Charter of 1661 introduced various changes. First was appointment of governor and council. The Charter of 1661 granted by the British King Charles II to the East India Company introduced radical changes in the existing judicial system. The company was conferred with powers to appoint governor and council in India. The governor and council of each place were empowered to hear and decide all civil and criminal cases of the servants of the company and those living under its jurisdiction according to the laws of England. Under the Charter of 1661, the cases of Indians inhabiting the settlement of the company were also to be decided according to English law. The powers conferred on the company could only be exercised by the governor and council. The company was empowered to send offenders for punishment either to a place where there was a governor and council or to England. Justice did not gain much by the establishment of the court of the governor and council, as it did not function regularly or efficiently or earnestly. In criminal cases, the accused persons had to wait for long before they were put on trial. The main reason for the delay was that the governor and council, like their predecessors, the agent and council, being conscious of the lack of legal knowledge, hesitated to decide criminal cases without consulting the company's authorities in England. And in those days, consultation between Fort St. George and London involved inordinate delay. There is a case on record dated January 31st, 1678, in which an Englishman charged with the murder of another Englishman had been rotting in the prison for 31 months in a pitiable condition without trial, as his case has been referred to London. In yet another case, a Portuguese inhabitant charged with the murder of his servant, a black Christian, was confined to prison and consultations were going on between the company and the Madras Council, which had asked the company to send out a sufficient power to proceed against him. These cases reveal a very deplorable state of affairs in the area of law and justice. Want of a due course for the administration of justice gave rise to many complaints, and reform of the judiciary thus became a great public necessity. A reference to the Charter of 1661 would show that it was not the lack of adequate judicial power, but hesitation bordering on apathy to use that power which was responsible for this sorry state of affairs. Dear learners, next was second stage from 1665 to 1686. The second phase of the evolution of the judicial system in Madras commences from 1678, when Swayam Master became the governor of Madras. He reorganized the entire judicial administration of Madras and introduced reforms in the working of the courts. The court of the governor and council, which was created in 1666 consequent to Mrs. Dover's case, was not functioning properly. Mrs. Essentia Dowers was brought to trial before the agent and council on the charges of murdering her handmaiden. As was their usual practice, the agent and the council, being unsure of their powers in such matters, referred the matter to the company's officers in England for advice. The company decided to give effect to the Charter of 1661 in Madras, and for this purpose granted the agent the status of governor. This step was necessary because the charter vested judicial power in the governor and not in the agent and council. One of the effects of implementing the Charter of 1661 was that the judicial power of the governor and the council extended not only to the British but for all the people living in the settlement. Thus, the agency of Madras became the presidency in 1665. Soon thereafter, the governor and council tried Mrs. Davis with the help of a jury. Both grand and petty juries were used. The petty jury consisted of 6 Englishmen and 6 Portuguese. This was the first jury trial held in Madras. Swayam Master became the governor of Madras from 1667 to 1681. The governor reorganized the entire judicial system of Madras, required introducing reforms in the functioning of the courts above it. The court used to meet twice a week and decide all civil and criminal cases with the help of 12 jurors. Now, the court was designated as a High Court and formally inaugurated on March 27, 1678. There was reorganization of Chowltry Court. The working of the Chowltry Court was also reorganized. The native law officers, namely the Adhigars, were replaced by English servants of the company. They were known as Paymaster, the Mint Master and Custom Master, and all the three were to sit as judges in the Chowltry Court twice a week. They could decide cases up to 50 pagodas. The governor and council, being the appellate forum, were empowered to hear the appeals from the cases of Chowltry Court. This court functioned till 1704. High Court of Judicature was another important reform. The Governor General and Council were declared to be the High Court of Judicature. Thus, the High Court of Judicature came into effect in 1665, which was shuffled with 12 members of judicial presiding officers. The presiding officers had sitting for hearing of the cases twice per week in respect of both civil and criminal matters, which includes the cases arising out of appeals from the Chowltry courts. It was to hear all cases of the inhabitants of both towns with the help of a jury, and also hear the appeals from the Chowltry court. The decisions of the cases were in accordance with the English law. Despite these changes in the administration of justice, the working of the court of governor and council did not improve much, as the persons in charge lacked competence and jurisdiction, and most of the times the cases were referred to England, which consumed considerable time and caused delay and hardships to under trials. This necessitated further reforms in the judicial administration. After this started the third period, that was spanned from 1686 to 1726. During this phase, two important courts were established in 1686. Firstly, Admiralty Court, and secondly, Mayor's Court. Admiralty Court. It was established in Madras on 12th April 1686, and the court proceedings started on 10th July 1686. The main objective of the establishment of the Admiralty Court was to stop the increasing number of criminal cases. The company was given a monopoly of trade in Asia, Africa and the America. And if any British wanted to do business, then they had to take a license from the East India Company. but the rights of the company were being violated. What were the functions of the Admiralty Court? The Admiralty Court, which was constituted in Madras in the year 1686 by the Charter of 1683, was headed by an advocate judge. For dealing with the civil law, one judge and two merchants were appointed by the company. The nature and jurisdiction of these courts extended to cases pertaining to mercantile or maritime nature, offences committed on high seas like trespass, injuries and other miscellaneous offences, seizure of ships or goods and forfeiture. Admiralty Court dealt with rules of equity, good conscience and issues pertaining to customs of merchants. The first judge appointed for this court was John Gray. A professional lawyer by name John Biggs was appointed as judge advocate, that is, Chief Justice of Admiralty Court in the year 1687. In the course of time, the jurisdiction of this court became a general court in the city, dealing with the matters of both civil and criminal. The Admiralty also functioned as an appellate forum in certain cases for the appeals arising from Mayor's Court. This court was functioning till the year 1704. In Admiralty courts, executive functions and enforcement of orders were governed by the governor in the council and judicial functions were carried out by the Court of Admiralty. Therefore, the distinction between the executive and the judiciary was well established and maintained. The post-establishment of this court saw a professional highness. The pre-establishment era had the judges who were mostly laymen and merchants, and the decisions of the cases only based on their limited knowledge and their common sense. But after the establishment of Admiralty Court, the judiciary functions and the justice delivery system had an advanced jurisprudence, as the presiding officers and judges were mostly proficient professionals of law. After the death of Sir John Biggs, the above features of Admiralty Court did not continue for a long time. Next is Constitution of Mayor's Court. Under the Charter of 1687, the English East India Company constituted the Mayor's Court in Madras. The year 1688 saw the establishment of the Mayor's Court in Madras as a part of the Madras Corporation, which came into existence on 29 September 1688. Under this system, aldermen and burgesses were conferred with power to terminate the mayor if he was found negligent of his duties. Englishmen were the only people empowered to become the mayor. The aldermen held the office as long as they stayed in Madras city. Indirectly, they held the office for life. Mayor and burgesses held the power to remove the alderman from office, also if he did not perform well. My dear learners, it's noteworthy to understand the hierarchy of the above mentioned courts. The Mayor's Court was constituted with the presiding officer called Mayor. Under him there were 12 aldermen and 60 and more burgesses. The mayor held the office for 1 year and was elected by aldermen every year. The first mayor and aldermen were appointed by the Charter of 1687. The maximum burgesses were not more than 120, who were appointed by mayor and aldermen. The mayor and the 3 aldermen were chosen by company who are only English servants and others are native to the land. The first time judge advocate of Admiralty Court became recorder of this court. A professional who learnt law was appointed as the recorder and he was attached to mayor's court, which was known as court of record. The mayor's court tried all the cases pertaining to civil matters and had pecuniary jurisdiction up to 3 pagodas. The mayor's court also tried all criminal cases with the help of judges and was conferred with powers of imposing fine as well as imprisonment. A man learned in law called recorder was attached to mayor's court. The mayor's court tried all civil cases up to the value of 3 pagodas and all criminal cases with the help of a jury and punished the offenders by fine or imprisonment. Appeals were allowed to the Admiralty Court. In civil matters, the Admiralty Court decided cases more than the value of 3 pagodas. In criminal cases, it had decided when the punishment was to lose life or limbs. Appeals from the mayor's court and Admiralty Court were heard by the governor and council. My dear viewers, the present module may be concluded with the observation that the world's history has repeatedly demonstrated that when one country invaded another, it imposed its own administrative structure and legal system. Similarly, during the British rule, the administration of justice in India was radically reformed and changed, especially in the system of law and justice in the Madras Presidency. The British government made adequate plans to give good governance in India. A great number of judicial reforms were introduced and laws were codified. During the period of 1639 to 1726, the administration of Madras underwent significant reforms. Even though the courts, the system of justice delivery and execution of laws did not live up to the expectations and necessities and rarely won the gratification of the native people. It has laid a great platform for the post 1726 reforms, which extended and established a great judicial system in India. With this, we come to the end of this lecture. Thank you very much.